Good evening. We're live here every Tuesday at 5 p.m. Central Time, 5 to 6 p.m. every week, live for past couple of years. Emily, what do you have to discuss today?
All right, today we want to talk about the EGLE Act. This is HR 3648 to remove the per country limit. It's starting to gain some traction in the House now that we're in the lame duck session. Where do we stand on it? What are the next steps? Is it something that might pass? We are also getting more and more details of people who have filed H1B petitions in the lottery, the registrations with multiple employers. We're seeing a lot of results of those, negative consequences on that. So we wanted to share that with you. And again, suggest to you that it's not a good idea. You should not be filing with multiple employers unless, of course, you get multiple offers from Facebook, Google, and those types of companies. All that's fine, but with multiple companies that are coordinating together, consulting type companies, be aware of that. We have some improvement in visa appointment availability, so we'll talk about that. And then, what happens in the situation where some of these unscrupulous employers are taking money from the H1B worker? What are your recourses in that situation? Can you get that money back? What's the process for that?
First, let's touch the issue of the EGLE Act. It's also called as removal of per country limit. It's also called as HR 3648 bill, Emily. Let's first look into the content of the EGLE Act to see if it's beneficial for the audiences of ours. Should they support it? Should they not support it? What are the pluses and what are the minuses for the individuals? So, can you point some of them?
Yeah, so number one, it does remove the per country limit, which is the cause of the backlog for Indian immigrants waiting, stuck in the EB2, EB3 category. As we've talked many, many times, we have our 140,000 green card numbers. Only 28% go to EB2, 28% go to EB3. But then when you have too many people from one particular country in line, they cut it down to 7%, to where this year we're only expecting 4,000 green cards to be available for all Indians in EB2 and then 4,000 in EB3, because we're seeing more and more people filing in EB1. There's less spill down. There's not going to be all that family spillover. So it's going to take decades for people to be receiving the green card. This eliminates that 7% cap, puts everybody basically in line based on priority date, not based on country of birth. So it makes it fair. It's an even playing field, takes your country of birth out of the equation. We're talking about merit-based immigration here, high-skilled immigration. Why should anybody's country of birth matter? So that's number one, and it phases it out over a 9-year period. So people from other countries who are concerned about this saying, well, now how am I going to get my green card if they're all going to people from India and China? That's not true. If you're in line now and you're from another country, you're going to be getting your green card still well before this even takes effect. So this will affect people 9 years from now, potentially, where everyone will be on the same footing.
Even later on also, they will all be in the same footing. It's not like anybody gets a preference, though.
Right. And on top of that, while you're waiting, once your I-140 has been approved for 2 years, you can file to get an EAD.
So, Emily, this is nothing to do with the phasing out of 7% of the quota. So if this bill passes, though, anybody who has an I-140 approved that has been filed 2 years ago and can file the 485 immediately. However, they will be subject to pay extra $2,000 fees, which seems to be, I don't like it, but I think so all of you guys will be fine with it. And also, Emily, one minus point that I saw in these people who have I-140 approved, I-140 filed for more than 2 years ago and approved. One of the other minus point I saw is that the children may not get the employment authorization, which is, I don't like it, but still, it's going to be better off than where you are right now. Instead of waiting for a couple of decades, not filing the 485. So there's an extra $2,000 fees, and there is an extra, the children may not be able to get the employment authorization. But still, do you advocate this one? Do you like this bill?
Yeah, I think it's the best of what we've been able to come up with so far. It's fair on both sides in that it does phase the change in so that anybody who's potentially in line right now from other countries are not going to be negatively harmed by it. anyone, once it has been phased in, anyone with an approved I-140 for 2 years can file the 485, regardless of what the priority date is. So again, everyone gets that benefit. So even the people who are potentially going to be harmed by losing their ability to file right away still will be able to file in 2 years.
Yeah. And then children are getting protection on the where if they are going to be age out, they're not going to age out if they file a 485 application. There are, for the people whose priority date may not be immediately current, as I pointed out, that you have to pay extra $2,000 fees, the children may not get the employment authorization. And when you renew the EAD, which is given for 3 years, not 2 years, but 3 years, when you renew the EAD, you may end up paying extra $2,000 fees, which I may not like it, but overall, I still want this bill. It definitely is a good thing for everybody, Emily. And Emily has already discussed for the people who are not from India. It's not for the people who are in the pipeline right now. It won't affect them because this is a phase-out period in the next 9 years. It slowly, gradually takes the per country limit off totally after 9 years. So if you are in the master's degree, a bachelor's degree, and you contemplate to get into this employment bridge program, you still will be fine. It's only for those people who are going to come maybe 5 years, 6 years down the line, they may be affected. And it's not that this bill is favoring Indians or Chinese, it's just taking the discrimination off. Do you see any opposition for this bill, Emily?
Unfortunately, yes. We've been getting a lot more information this time around from Twitter. Has been very helpful, sharing kind of what things are being spread around back channel. And so we have some people who are against this because it does harm, in their mind, people that are not from India or China, and feeling like the only way to fix this is to increase the number of visas to make it fair for everybody, which that's not going to happen in the current political environment. There are other people saying, well, this is going to harm Black migrants, or we can't do this unless we fix Dreamers. We can't do this unless we fix asylum. We can't do this unless we fix border protection and all these things. So it's already getting people coming at every side, immigrants pitted against each other.
Yeah, this is discrimination. They are trying to remove the discrimination, though. So let's say when we are fighting for the Black people at that point of time, where people were discriminated based on the color, brown, black, yellow, whatever color, we don't speak about that. It doesn't mean that ladies were not discriminated. That's different, and this is different. Just because we had equal rights, ladies were not given equal rights back a long time ago. They were not being given voting rights until about 20th century, though. Then what do you speak about? I mean, yes, that is discrimination. Discrimination in any form should be taken off. Now, we're speaking about discrimination based on the birth, though. If somebody is discrimination because they are smoking, they are drinking alcohol, or whatever good or bad things, depending on how you feel, that's fine. That's their choices you're discriminating on. But if you're discriminating based on the birth that people don't have any control, whether it's been a gay, lesbian, woman, black, brown, yellow, that is a complete discrimination. If you're discriminated based on somebody smoking, I don't like them, that's fine. But this is a discrimination based on the birth, though, which people don't have any control about where they're born at, which country they're born at. If this has been taken off, I don't think so the other minority group should attack it. In fact, they should support this group because, hey, you were at one point of time discriminated, or maybe you're discriminated right now. So you should support this bill instead of opposing this bill. We have put a draft, guys, and a lot of people are asking, is it passed? Is it going to pass? It depends on you. Remember that last year, at this point of time, we have advocated for you to write letters to the congressmen, senators, and you wrote letters, 280,000 green cards were being used. If you wouldn't have written the letters, though, we would have wasted 140,000 green cards. We have given a draft of this letter. At the bottom, please modify it to whichever you want to. Write it to the local congressman. The link is provided to you there. Write it to the 2 senators that you have. And why is it so important right now, Emily, for this bill?
Right. So this is where we're at with this bill. It is expected to be voted on in the House on Thursday, this week. We're in the lame duck session.
Tuesday, Wednesday, Thursday.
2 days from now. There was some discussion of it today. We were thinking the vote might happen today. They were talking about the rules they were going to have and how long they were going to debate things on the floor. It's very complicated, but as of this moment, it sounds like the vote in the House is going to happen on Thursday. We have a very limited time because Congress is only in session right now, scheduled through December 15th, 10 days from now. So we've got about 10 days to get this through the House, through the Senate. And if the Senate does a different version of it, then we're back to where we were last year, where they're going to have to come back together to come up with a final version of the bill, get it passed, get it to the president's desk. So it is very important, number one, to contact your congressman, your House of Representatives, to make sure that they are going to vote in favor of this bill, and reach out to your 2 senators so that the Senate is ready. Now, for the Senate, that's where we always have the big problem. The House, hopefully we can get this to pass.
We have this bill passed a couple of times in the houses, right, Emily?
And we got it passed in the Senate last year too, but now the Senate, we need 60 votes in the Senate. They try to do all these things through reconciliation where they only needed the 50 votes and that didn't go through. So now we have to have 60 votes. We have to get Republicans on board with this. And hopefully, because it's a small bill, it doesn't have a whole lot of other immigration things tagged onto it. Maybe we can sneak it through this time.
But this is a time, guys. Once we hit January 3rd, we are dead. We are not going to have this bill passed. Then we have to wait for 2 years. Who knows what's going to happen after 2 years? This is the window. We've been waiting. We've been all the time telling that this is the time. The lame duck session, that Congress elections are over. The new Congress is going to come into place on January 3rd. So this bill has to get through by that time. If not, well, you guys have to wait for... Emily was wrong. She said decades. No, she is wrong. It's centuries. It will take centuries for you guys to get the green card. She's wrong. It's not decades. Let's go to the next topic, Emily. Now, what about this H1Bs? We have, people are applying, Emily. This is my last time. This is my first time. Hey, what the heck? It's only $10. I will apply from multiple different companies. What's the negative consequences for doing it? And why is it so important? Why is it coming to more attention right now?
Yeah, we definitely have been talking about fraud in this lottery system, the new version of the lottery system where it's electronic. It's very easy to do. It only costs $10. So companies don't have a whole lot to lose if they submit lots of registrations. There were, 483,000 registrations last year, up from 350,000 the year before because of this electronic system, because it's so easy. Now, again, people who are on their OPT, on their STEM OPT, they feel like the third time, this is my last chance, I have to get selected, so I'm going to go to multiple employers. Or sometimes they go to one employer, and that employer then works with other employers that they are connected with, and they get submitted multiple times. And then they run the lottery. They don't look into any of this when they run the lottery. They just run it, select people, and then those selected file. But what's happening now, USCIS is catching on to this a lot earlier in the process. Before it was, we're going to let you file, we're going to approve your petition even though you filed.
And then we'll let you transfer to a different company and then catch you.
3 years, 6 years later. Now, in the initial filing, we're seeing notice of intent to deny because USCIS is seeing that this person had been registered with multiple companies, and then they're able to look at those multiple companies, and they're finding that the same group of companies submitted registrations for the same set of employees. Like 5 companies submitting for the same 40 people. That's 200 registrations right there, and only 5 of them are probably valid. So that they are putting 2 and 2 together and figuring that out. They're sending notice of intent to deny those petitions.
One of the cases intent to revoke also.
Yeah, so that's a good thing. They are catching it. Still, it's after the fact. So people that didn't get selected are still harmed by this, because what's going to happen when they go back and deny these or revoke these? They're not putting those numbers back into the system. They've already closed out this year's lottery. So it's still not solving the problem. But at least it's an improvement that people aren't getting away with it as much, hopefully.
How do they determine that they are filing multiple applications? One simple thing is that they look at the date of birth of you, they look at your name, and they will search, and then they'll find out that you have registered multiple sites. Now, if the multiple companies are, for example, Apple, Google, Facebook, do you think so that they will consider no? What if this particular is a small consultancy organization, which most probably was formed in 2019 or 2020, and which has operations only in a small facility, and they filed for multiple people who none of them were actually being employed with that company at the time when they filed the H1B. How do they know it? When you file the H1B, you'll have to tell from what time you are working for that company. So that's another determination. They will find out, these guys went and filed multiple things. They look into the common ownership, sometimes common address, common FedEx, a lot of different things that they find out right now. And when these people have a lot of electronic system, the main thing they're finding out is the date of birth and your passport number. That need to be given there, your name. And then they look into all the things and find out and sending notices to these things. It has become a boilerplate. In the past 1 week, I've received, I would say about 10 days, I've received 4 consultations where either the notice of intent to deny or revocations have occurred on this one, where the companies have filed for multiple beneficiaries who are not working for the company. And beneficiaries also filed through multiple companies, and I saw the intent to revoke. So if you are one of those beneficiaries who have used multiple companies, it may be right time for you to contact a lawyer, because there are some corrective steps that you can take care of it to rectify the mistake. Or if you later on come to know that you got an intent to revoke or intent to deny your H1B, or when you transfer your H1B to a different company, that may be the right time for you to contact the lawyer too. But be aware, for those people who are going to file the lottery next year, don't fall into the trap of these people. The companies, what will happen, these companies, is that when some criminal investigation happen on this, which normally happens, that's it. They leave the bags and they go to India. And the USCIS doesn't have the resources and energy and money to go after these people all the way to India, catch them, bring them here. They don't have. They do sometimes do that, but very rarely they do. What will happen to the employees is that they will be the persons who will be affected. Their future will be completely destroyed. I would recommend to wait for 1 more year, 2 more years, you'll get it. Don't go through these companies. Anything else, Sandy?
All right. I also wanted to talk about the visa appointment availability. We're now hearing that we're in December right now, people are actually able to get their interview appointments in India in January 2023. So only having to wait 1 month for those appointment slots, which is very good sign. We're hopefully getting back to pre-COVID levels on that. But at the same time, we have some concerns, because while we're seeing more and more people getting appointments, we're also seeing more and more 221Gs, or administrative processing. What does that mean, a 221G?
Emily, why is that previously when the 221G was issued, it was an administrative processing? Now they say it's a denial and administrative processing. Can you explain that, Emily?
I don't know. There's no reason behind it. I don't understand how you can deny a visa but still process it. If it's denied, then it should be over.
And then when they issue 221Gs right now, Emily, if they take a long time to adjudicate the application, is there any solution that you have?
Yeah, so we've actually started suing the State Department on these 221Gs, because they're putting you at administrative processing, and that's fine if they have to do some background checking and they're actually doing something and they're actually going to issue a decision in a reasonable period of time. But what's really happening is they're just setting that file aside, moving on to the next one, and waiting forever, 8 months, 9 months, 10 months, still nothing happening. And then by that point, you lose the job, and then they don't have to process the visa. Instead of that, we are filing lawsuits for the unreasonable delay, and we're starting to see some positive results of that. We have some that were subject to that extreme vetting form, that DS 5335 that came out with the Trump administration. We filed a lawsuit in November. Person got the visa this weekend. So we are definitely seeing some positive reaction to that, because they can't just put the case on hold. If you're going to deny it, deny it. Otherwise, approve it. Why does it need to be stuck on hold forever? And so I think that they are opening up more appointments because they're getting a lot of pressure from Washington, D.C., from senators on people not being able to get these appointments, but they're not going to be stepping up their processing. They're just going to 221G.
Yeah, I mean, at least 95% of the cases will be resolved immediately. It's only 5% of the cases that wait to 221G. Overall, I have to say that even though you can sue the State Department if there's a delay, but overall it's just better because the appointment system is not backlogged to 580 days. Definitely not. It's very good right now. We do expect this to continue for a long period of time. But if you have any cases that stuck, you may want to consult a lawyer. Don't let it leave there and wait there for a long period of time.
All right. I also wanted to talk about the unfortunate situation sometimes with unscrupulous employers. They may ask an H-1B worker to pay money for things that they're not actually allowed to pay. So if you have an H-1B worker who's in that situation, who they've given money to the employer that you're not allowed to pay for filing fees, you're not allowed to pay for attorney's fees, for expenses associated with getting the LCA or filing the H-1B petition, only certain things can be deducted from an H-1B worker's pay. So if you've actually had these unlawful deductions or even given money to the company, what steps does that person need to take? Can they ever get that money back?
Now, when you say given the money, though, Emily, there are different ways the employer asks the money. If they don't ask by check and they ask by cash, they sometimes even ask the money in India. Even if you have done any of that activity, you can get the money back from the employer. It's very easy, guys. It's the easiest thing. All you need to do is that there is a form called, please note it down, WH4 Department of Labor. Google it, okay? WH4 Department of Labor. You type it in you will get a form. I don't want you to send the form to the Department of Labor. The reason is that, let's say, for example, this guy has taken money for hundreds of people. The Department of Labor comes and investigates this company. That guy just leaves the country and goes. You won't get your money. So what I recommend is you fill the form out. Don't send it to the Labor Department. You send it to the employer. You ask, hey, employer, give my money. Otherwise, I'm going to send this one to the Department of Labor. And if that guy doesn't, go ahead and send it to the Department of Labor. They'll investigate it. Because he's not going to pay anything. So you better get to the Department of Labor. Even if you have paid the money to your cousin, to his cousin, there are ways to, you can complain and let the USCIS know, let the Department of Labor know. The Department of Labor, then what it will do is that they will go to all employees, they will ask with all the other employees, have you paid the money? Is there a chance that you may have paid the money back in India? Then the company will be in trouble. So they will corroborate with all the other employees to see if this employer had done any of the bad activities. So WH4 form is the best solution that you have. Anything else?
All right, I think we can move on to questions.
I just have some quick things that I want to update. EB1A and EB1C's approvals rate have gone significantly higher. Even if your case has been previously denied, you may want to reevaluate your case, though. One of the person has asked, Michigan State Grant Start Program. I checked around it, where it allows the children who are under the age of 5 years going to school. Is that going to negatively affect as a public charge or on the H1B or green card? The answer is no. They can go. If you get laid off, if you're on H1B, if you get laid off, you're in India, don't try to travel on the H1B, because once you don't have a job, you should not travel on that one. Labor Department is taking 7 months for the prevailing wage and approximately 7 to 8 months for adjudication of the labor certification. So other than that, there's approximately 3 months. So it may take approximately 2 years for you to get the labor certification approval. So please start that very early. A lot of people ask me this question, should I move on to GCEAD or should I be on H1B? If you really want to, normally EAD is easier for us to work with. It's easier, no end client, no filing fees, it's very simple. A very simple form. You don't have to provide end client information or LCA, nothing is required for it though. But if you think so that you may have some problems in your history, you may want to evaluate yourself to see if you really want to move into EAD. For example, if there is any status violation only, not unlawful presence, for example, if you have traveled outside the country, it erases all the things. If you travel outside the country, so you're still fine in getting the green card. So you may want to evaluate with a lawyer to see if there is any problems and potentials. Do you want to carry this extra burden? We don't know how long it's going to take. If the Eagle Act passes, most probably your priority date will be current and you'll get the green card. But if not, you may take a long time. You may want to evaluate yourself to see if you want to stay on the H1B or move to green card. EAD, sorry.
All right. One of the questions from Amir is about whether layoffs at other companies could potentially affect a PERM application for a company that did not experience a layoff. So once the PERM has been submitted, layoffs that occur after that would not have any impact. Generally, layoffs at another company don't impact the company that you're filing with. Where it can become an issue is if there's layoffs happening at other companies. Some of those may be U.S. workers, and they may be applying for jobs at the company that's getting ready to file the PERM. So you may have more qualified or potentially qualified U.S. workers available, which means that you cannot proceed with the PERM if there are U.S. workers available, willing, and able to take the job that you're being sponsored for. So that would be the possible impact of having layoffs at other companies if that would make U.S. workers available to take the job that you are being sponsored for.
A lot of people are questioning: is the Eagle Act passed? Will it pass? It will never ever pass. Has anything passed in the lame duck session? Yes, lame duck session is a very active session, guys. A lot of controversial bills get passed in the lame duck session. Why is lame duck session important? This old elections are over, guys. No more elections for the next 2 years. The last election actually happened for the Senate of the Georgia today. It's over. We would be getting the results soon at about 6 p.m. or so. So even that is over right now. There's no elections there. So now the congressmen and the senators, they don't have to face up people for the next 2 years. This is a time where they pass the controversial things. So yes, lame duck session is important. Will it pass? Depends on your pressure. Depends on how you contact. Emily, we are already getting information from the opponents. I don't know about you guys. Did you want it to be passed? If you do, keep writing letters. That's all we can say. You did wrote the letters of 280,000 green cards. You got the 280,000 green cards. Well, most of our audiences are not there because they got the green card. They left, which is very good. We like them. But now we have fresh audiences who did not get the green card, who are still waiting for the green card. Do you want to be out of this video sessions? You don't. I mean, if you don't want to keep coming to these video sessions, well, keep writing the letters. And if you want to keep coming to these video sessions for the next 50 years, even if I'm dead, some other lawyer will be there, okay? In the next 50 years, yes, don't write the letter, guys.
All right. Josh has a question about expiring passports. And this is expiring in September of next year, but he's going for visa stamping in March and wants to know if there's going to be a problem coming back into the U.S. So because it's less than 6 months validity. So there is, you can travel back, you can get the visa stamp. Where the problem is going to be is that when you're coming in and your passport is expiring before your visa or I-797 approval notice is expiring, you're going to get a shortened I-94 that's valid only till the passport expiration. So if you're coming into the U.S. in March, and you have an H1B, for example, that's valid for 2 more years, you're only going to get an I-94 that's valid till September. You have to take action to fix that before September. The easiest way to do that is to get the passport renewed and then travel one more time before this I-94 expires, and then you'll get the full period of the I-94. But make sure you do that before the shortened I-94 expires.
Shiva Rajan has this question. I'm on H1B now. I want to move to L1. Can it be done from USA? So you want to move from H1B to L1 in USA? If you are eligible for it, absolutely you can. You don't have to leave the country. You can apply for a change of status from H1 to L1. Make sure you apply for your dependents too, otherwise they'll go out of status.
There's not a lot of reason to do that, though, I want to point out. because number one, the L1 does not get the benefit of extending beyond the 5 or 7 year limit based on an approved I-140, which the H1 does. You don't have to be in L1 to file an EB1C. If you qualify for L1A, you might qualify for EB1C and not have to switch to the L1.
So a lot of people think so that to file the EB1C, you need to be on L1. That's not true?
That's not true.
Okay, so most of the people who wants to move to L1 probably wants to get to EB1C.
Right.
This guy, if he's eligible for L1, probably L1A, he's probably eligible for EB1C.
Yeah, and on top of that, like if we're talking moving from H1 to L1B, well, the time spent in H.
Oh, H1B? No, I don't think so. They will ever move.
Right.
No, they will not move from
But
H1B.
even for L1A, remember the time that you spent in H1 status counts against you for the L1 limit. So if you've already spent 6 years in H1, you're only going to get a 1 year L, and having an approved I-140 doesn't allow you to extend beyond that. So there's not a lot of reason to do that unless you're just trying to test the waters for a potential EB1C. Then you may want to. Another question about passport renewal. What happens when I renew the passport while the H4 extension is in process? Nothing at all. You don't need to do anything. Doesn't matter. USCIS just looks at, was your passport valid at the time you filed the extension? They might, if they see by the time they're ready to adjudicate the H4, the passport's already expired, they might send a request for evidence asking you to send in the renewed passport, but you don't have to proactively do anything.
Jimmy is from Germany. His labor certification has been filed in May. When would he be expecting an answer? It's taking about 7 to 8 months. So May, June, July, August, September, October, November, December. Yeah, I would say that by January or so, you should be expecting a result. Jimmy, I would recommend that once your labor certification is approved, you should try to file I-140, and there's also 485. The reason is that, assuming that this is the first time you're filing the labor certification, your priority date is May of 2022. We are expecting for Germans also priority date to move back. So please be mindful about it as soon as you get it. If the priority date is current, try to file the 485 application as soon as possible. There are a lot of questions that are coming on with regards to EB1C priority date. EB1 priority date, not say EB1 priority date. EB1 priority date, if it moves back, how far it's going to move back? Is it going to move back only 3-4 months? No, it's going to move back approximately 2 years is the estimate, Emily. What do you think? Yeah.
We're always wrong, so I'll just agree and say.
Yeah, it won't be 2 or 3 months. It will be a couple of years, especially for the Indian nationals and Chinese nationals. We are expecting EB1 also to move back. So if anybody has an I-140 pending, previously some of the lawyers may have recommended that to wait until the I-140 is approved, especially if it's an EB1C, because the premium processing still you have to get, you can't just file the premium processing immediately, you have to delay for a certain period of time. EB1C, you may want to consider filing a 485 application. Even for the EB1As and EB1Bs, you should consider definitely doing premium processing of your I-140 and then consider filing 485 together, because if it moves back, then you would not be able to file the 485 application.
Arun says, I've been hearing multiple answers to the same question. If someone's on H1B, leaves and comes back on AP, does it automatically put me in AOS status using my EAD or H1B? The reason you're hearing multiple answers is because there's no clear answer from USCIS on this. What we do know is USCIS has an old memo that says that if you enter on AP, you are allowed to extend your H1B after you entered on AP, and the approval of that extension puts you back in H1B status. The question becomes, from the time you enter till the time you get that H1B extension approval, what is your status? And the memo does not answer that. And what's funnier is this memo is just meant to be kind of interim guidance until we actually got regulations that implemented this AC21. We did finally get the regulations 20 years later, and the regulations are completely silent. They didn't even answer the question. So we're still going by that memo, but yeah, it is not clear, and that's why you're getting different answers.
And each lawyer interprets differently. What I interpret is, look, you can extend the H1B, you can transfer the H1B, you can even apply for the change of status of H1B. So it says, quacks like a duck, walks like a duck, feels like a duck. It probably is a duck, is what my answer is. Emily is saying, maybe not. So that's the reason you see a difference of opinion between lawyers. Um, Question with regards, two of the people are asking the question, does this Eagle Act provide any benefit to the to be aged out children? Yes, the Eagle Act says that if you file a 485, now there are two 485s here. One, if the priority date is current, which you know how it works out, they're already protected anyway. Now, the Eagle Act also provides that even if the priority date is not current, if you have filed the I-140 application more than 2 years ago, filed, not approved, and you have it approved by this time, which within 2 years, of course, you get an I-140 approval, you can file the 485 even if the priority date is not current. Now, here is the scenario. Once you file the 485, the child is locked. He never gets aged. So, which is very good for the children though. So, Bobby and Rishi, that you're asking this question, please, you need to write letters to the congressman, because especially when it involves the children though, the congressmen are very sentimental though. These children who has gone to the high school, are going to the high school here, or going to middle school here, they're very sensitive for those kids. Have them write the letters too, if they are of a proper age. Have them write the letters. Look, I'm 16 years old. I will be out. I know this country. I don't know of the other countries. My parents have been maintaining legal status. Is that a punishment you're going to give it to me by kicking out? So please have them write these letters. The draft of this provided. Please use those things.
Jimmy had his perm filed in May and wants to know when can he expect to hear back on that. He's from Germany. So they're taking, we already got that one, 7 to 8 months.
Whether the October 2013 will be current in EB3 or EB2, I can say, Praveen, if the Eagle Act goes through, yeah, for sure, it's going to be current soon.
Sushil says if the person lost the job connected to a primary H1B, this is where they have a concurrent H1B. So they lost the primary job but still have the concurrent job. Is the concurrent H1B enough for status, or do they have to switch? There's no guidance here. So because the second H1B was filed as a concurrent H1B, my interpretation is that you need to file a transfer to the concurrent H1B employer within 60 days, within that grace period.
What is the processing time for the AP? Well, in some cases, it's only getting adjudicated in 2 months. In some cases, it's taking 13 months. Unfortunately, sometimes they are segregating between EAD and advanced parole. EAD is getting approval faster. Advanced parole is getting delayed. Unfortunately, that's what is going on.
Amir says, are there any expectations for the perm processing times to go down? It was previously mentioned that they were hiring 19 additional people. I don't have high hopes, and there's a couple reasons for that. Number one, they are about to get into the H2B season where they're going to have all these peak filings happening. So they're definitely going to be shifting resources around to take care of that. And number two is kind of based on some information they gave recently about why prevailing wages are taking longer than usual. And not all of them, but there are some that are very long pending. And they came out and said, oh, it's because when we implemented the change in the SOC codes from 2018, we didn't have all the data available. And so we're having to do extra research to issue those prevailing wages. And so we have some prevailing wages that are pending a year because of that. Now, come on, they knew this was going to be implemented all the way back to 2018. Why didn't they have the data they just seem to have an excuse for everything. For the longest time, it was COVID, and then it was we need more officers, and now it's we have to do extra research. They just come up with an excuse for everything. So I don't have high hopes that things will improve on processing times.
Follow-up question on the L1 visa. Can we not get 3 years more beyond 6 years on L1 if the I-140 is approved? No. L1B is 5 years, L1A is 7 years. If you have an I-140 approval, can you get more? No. That provision is only for H1B. It does not belong to L visas. Ravi Raja is writing letters to the congressman. That's very nice, guys. That's very nice.
Ashish says, I have an approved I-140 and I'm looking to switch jobs. Is it required to have the original education certificates for the new job, or is soft copy enough? You don't need the originals of any of the documents related to filing the labor certification or I-140. The copies of your educational documents are totally fine.
Questions on the EAGLE Act. Can the dependents get an EAD in advance parole? It's only this, when you read the law, it says that dependents otherwise eligible for the EAD will be eligible to get the EAD. So since most of the people are L2 or H4, I-140 already approved for the spouse, they're already eligible for the EAD. So they definitely are eligible, but the children of, like for example, L2 children don't get an EAD. At the same time, H4 children don't get the EAD. So thus, they are not eligible for the EAGLE Act. There are two adjustment of status there. When the prior date is current, when the prior date is not current. When the prior date is not current, children will not get an EAD, but spouse will get an EAD in advance.
Shanez wants to know, how do I find the congressman in my area? So we should have instructions for that. If you look down in the below the video, you should be able to find those. But basically, you can Google "find my representative, find my senator," and then once you get to that page, you put in your zip code. They may have you put in the street address, and it will spit out to you who your person is, and it will send you to their website, and you'll get all their contact information from there.
The Science, Space and Technology Veteran Affairs, that is a little bit different letter. That's a different law than the EAGLE Act. It's not that we're opposed to it, but right now, EAGLE Act is the one which is going to hit the floor. This is the right time for you to contact the congressman. Will the EAGLE Act permit filing 485 application for an approved I-140 from a previous employer? The law is not clear. I couldn't determine if you would be able to file. It said for sure that you have to file a 485J supplement. It didn't say that the 485J supplement has to be with the same employer. I still will be a little bit more conservative and say that probably at this point of time, unless more clarification is given, you must, the same employer that has an I-140 approval, they will be able to file the 485J supplement, that's for sure. Can a different employer file in the initial filing? I really don't know at this point of time. So I would be very conservative and say only the employer that filed an I-140 can file the 485J supplement. But if things changes, I'll let you know.
Money says, I filed my 485 back in May 2022 in EB2 and have the EAD and AP, but my wife was in India at that time and we couldn't file. Now she's back in the US on H1. When can I file? So assuming that your priority date retrogressed after you file, you have to wait until your priority date becomes current again, and then she can file a 485. She has to make sure she gets it filed before yours gets approved, so they can be, she can be approved as your derivative.
What is locking age of child? Priya is asking that question. We put a separate video called CSPA, Child Service Protection Act. Priya. Now, as you know that when you get a green card, your child, if it becomes 21 or above, normally is not expected to get a green card. Then he has to go on F1 and then have to swim the same way what your husband might have been doing it. Now, there are some provisions where the child age can be locked. For the child age to be locked, there are 4 things that should happen here. 1, your I-140 must be approved. Second, the final action dates must be current. Now, please make a note, final action dates need to be current. Third, your child must be under 21 and you must have filed the I-485. All these 4 things should happen at the same time. Now, child is under 21, there is a exceptions to it. The time period the I-140 is pending will be deducted. So if your I-140 has been pending for 1.5 years, if your child is 21 years and 8 months, for the purpose of the child locking, he is still under 21. So all 4 things need to happen and his age need to be under 21 under the Child Service Protection Act. Then the age gets locked. That means that if the final action date is current and then later on it moves back and the date never becomes current in the next 10 years, if your child is unmarried, he will still get the green card. So child locking is very important. We made a 10-minute video called CSPA, Reddy Neumann. You search in the YouTube, you'll find it.
Srinivas says, my 797 starts in March 2023. My visa stamp ends in March 2023. And in the, so we already got an extension that goes till 2026, but at the port of entry, they gave an I-94 only till March 2023. Does that override the future I-94 that takes effect in March? Depends on which one was issued first. So there's kind of a unwritten rule called the last action rule, where the last action is the one that controls. So if you got the extension first and then traveled and got the new I-94 that's expiring in March, that I-94 controls. If you traveled first and then got the extension, that extension approval is the last action. The extension I-94 controls. So yes, I would operate under the assumption that your I-94 is expiring March 2023 and that you need to travel to get the extended I-94 till 2026 or refile that extension.
Please don't keep on asking me, guys, when the prior date is going to be current. Please take an action by yourself, writing a letter to the congressman. I can assure you that if the EAGLE Act passes, though, the priority date for the Indian nationals is going to move faster. I will guarantee that to you. That's all. Whether it's going to move or not without the law, I don't know. Can we transfer H1B with approved I-140 from non-profit organization to profit organization? There are two questions here, Shiva. You can definitely transfer I-140 from non-profit to for-profit organization. You can put the date, you can put the priority date, you will be fine with that. However, if you are on H1B with a non-profit cap exempt H1B and you want to go to for-profit organization, though, you need to go through the lottery system. Now, the good part is that even after you complete the 6 years, you can still go through the lottery system. That's a good part about it, right? Yeah, you can still go through the lottery system. But if you just want to move I-140, that's a different issue. As far as the lottery, that's a completely different issue. You need to go through the lottery system for H1.
Sen says, if the EB3 India is current, is there anything that can be done for a pending 485 case to actually get it adjudicated, or just sit and wait knowing that retrogression may be coming in the future? We definitely went through a lot of that with all of these October 2020 filings and then the later filings, trying to get them all approved before September 30th, 2022. What we do know is make sure your I-140 is approved. Make sure you've got the medical exam submitted. You can do that through interfiling. You don't necessarily have to wait for an RFE. Beyond that, I don't think there was anything else that you can do, because if the case is considered to be within normal processing time, you can't do a service request or an e-request. There's not much else you can do other than wait.
Ravi Raja has this interesting question. Eagle Act is just introduced. What are the chances to be law-based? What are the chances to be passed? Why not other similar acts which have been put earlier? There are a couple of things that I want to note down, a difference between the Eagle Act and the rest of it. This Eagle Act is promoted by Jo Lofgren. She is a very nice congresswoman from San Jose area. She understands the immigration much better. She is in favor of this removal of the per country from the long period of time. She's been advocate of this for a long period of time. She is one of the candidates, if you don't remember, it's been very old, guys. In 2007, we filed a lot of 485 applications that would have been, all the 485s could have been rejected. She was a goddess to keep those 485s. She fought on behalf of the Indians and kept the 485s. Now, she is the Judiciary Committee chairman only until January 3rd, even though she was in the opposition for a long period of time, okay? Especially at the time when Obama was there for a long period of time, and when even Trump was there for the last 2 years of the Trump era, she was able to get this bill passed in one way or the other. Right now, she is the Judiciary Committee chairman. She has the House under, she has houses under the Democrats have the House right now. So she could be able to, she's in a very good position to pass this bill. However, if you guys don't keep on writing letters, people, they see, oh, it'll never be passed. You should try to do your effort. She's doing her efforts. She's fighting for you guys. You keep writing letters to your congressman, put a pressure on your congressman too. So this is the right time to pass it. We have the Congress president, the Senate leader. The Senate leader happens to be an Indian origin lady. I visited India so many times. The vice president of the United States is head of the Senate. And House Judiciary Committee is headed by Jo Lofgren. She is very nice person for the Eagle Act to be passed. Now, after January 3rd, she will not be there because the House has moved to the Republican Party. She will not be the chairman.
Narasimha says, is it possible to file the 485 along with the I-130 for the spouse of a green card holder where the spouse was in H4 when the EB2 485 was filed? I'm assuming this situation is you both filed together in EB2, the main applicant got approved, and the H4 dependent did not and is still pending. And you're wanting to know, where does it say in the law that you have to be maintaining your H4 status to file the 485? That is in the statute. Anyone who's filing an adjustment of status application always has to document that from the day they entered to the day they're filing the 485, that they have properly maintained their non-immigrant status. That being in adjustment of status, which is what you are now, because once your H1B spouse got the green card, you're no longer in H4, you're in adjustment of status. That is not a non-immigrant status, so that doesn't count. On top of that, employment-based and family-based have different rules. The employment-based has a special provision called 245K, which can allow you to be out of status for up to 180 days and still file the adjustment of status. That does not apply in the family-based system. Therefore, you have to be in a non-immigrant status on the day you're filing this new 485 in the family-based category. So it is required for you to have some kind of non-immigrant status. Otherwise, you have to consular process the family-based green card.
Shiva is asking this question, how do you know that your H1B is being filed under the cap exempt? Well, simply look into the H1B application. It says whether it's a cap exempt or not. Now, I will say that for for-profit organizations, mostly 99% of the time or 98% of the time, they are not eligible under the cap exempt though, okay? The universities and all those things are cap exempt. Now, even if they are cap exempt though, do they have to file in cap exempt? Can they still file in cap? The universities can also file in cap. There's no requirement they have to file in the cap exempt. Simply look into the H1B petition. If your employer is not giving, do FOIA, Freedom of Information Act, USCIS, and you can fill out a form there online. It takes only 5 to 10 minutes, no filing fees, nothing. Even though they say that they're going to charge you some money, I've never seen them charging any money. Even if they do, it's going to be $20. You can afford it, guys. So, and they will give you the information of your H1B petition. You can see if it's been filed in a cap or not.
One of the viewers had mentioned about, tweeting to the president about removing the country cap and being on social media and that sort of thing. And I really want to address that because what we've been saying for years is write a letter. Letters work. We know they work from an advocacy standpoint. At the same time, you see a lot of people posting on social media, talking on social media, retweeting, copying in, messaging the senators, the Congress people, the president, all those things. Social media does nothing to actually get this passed. So you might be using social media to maybe let people know that this is an issue and what your opinion is on the issue. I guarantee you not one senator is looking at their social media and saying, oh, 20 people retweeted this person who says I should pass the EAGLE Act. Maybe I'll pass the EAGLE Act. It doesn't happen at all. They could care less what is on Twitter. They don't look at Facebook. That is not where advocacy happens. So yeah, go ahead and talk about it on social media. We get a lot of information from there, especially from the reporters that have been reporting on this, which is great. But do not rely on social media to advocate for the EAGLE Act. You have to send letters.
In the social media, how does a congressman know you belong to that particular constituency? What is your story, though? Is it how easy for you to just retweet it? How easy for you to just say like it? And there are petitions that people visit 10,000 signatures. How many times have we done that? Does it ever work? Do we ever know? Now, I'll tell you that I get so many emails from the people who write the letters. They get a letter from the congressman. I saw this one. I understand your pain. I am supporting this bill. Sometimes they may not support the bill. I mean, sometimes they may say that they are not support. That's fine. You still need to express your things to see. I see a lot of times a congressman writes a letter back to the individual who writes the supporting letter and tells them, I am in support of this bill. And people ask question, if they are supporting the bill, why should I write the letter? Well, you should make them support better. Have a better voice. Or if they are not going to support, what is my letter going to do the difference? Yeah, it's going to tone down the efforts they will do. For example, I will tell you in Senate though. Senate requires 51 votes, but there is something called filibuster, which requires 60 votes. So they may not emphasize on the filibuster. Who knows? You don't want that guy, even if that guy is opposed, he may not use the filibuster. So please write the letters, you describe it, give it to them, especially if you have children who are under 21, who are born in India. That case will make very good in the EAGLE Act because your child is going to suffer if this bill is not going to pass. The same length of journey that you took to get the green card, double it for your child. It will be much double for that guy to get the green card. You want that pain to go through? Well, I don't know what to say about you, but I definitely don't want your child to go through that pain.
All right, well, I think we're out of time for today. Thank you so much for joining us. Please make sure you contact your senator, contact your congressman, spread the word. All the people that used to watch that got their green card, reach out to them and tell them, hey, we don't want to be in the same position. Please reach out to your senator as well on our behalf so we can hopefully get this passed. We've only got a very short window.
Thank you very much.